protection unions in Mexico colluding with bosses, keeping wages low, so that almost 30 years into NAFTA, Mexican workers' wages in manufacturing are actually lower than Chinese workers' wages in manufacturing. This is an untenable situation. It is a fundamental human rights issue. And the new NAFTA, the revised NAFTA, is designed to try and take on some of those issues. And these are, you're going to hear from some of the people who are trying to make it work. We are also going to be today releasing a new public citizen report that dug into the Mexican government data with respect to the implementation of the new labor court and institutional justice system that is both an obligation of Mexico's labor law reforms that flow out of Mexico's constitutional reforms for labor rights, and that are also obligations of the revised NAFTA. Those new institutions are to replace what have been captured institutions that have helped, if not facilitate, certainly tolerate protection unions and a system of labor unions that do not represent the interests of workers, but rather the bosses. So the new institutions are obviously a key part of the story of improving working conditions, wages around North America. So just once again, in case you came in late, we are very honored to have Susana Prieto with us. She will be speaking in Spanish. If you need interpretation from Spanish to English, please see the buttons in your Zoom near the Q&A at the bottom. It says interpretation. There will be live Spanish to English interpretation there. You can switch languages if that is useful for you. And obviously, if you have questions that you want to ask to Susana in Spanish, that will be interpreted as well. There will not be interpretation the other way around. So this will be Spanish to English. Use the interpretation button on the bottom, please. So many people in all three North American countries fought very hard to document the damage of the old NAFTA and that model of race to the bottom working standards, but also to try and fight to have a different kind of agreement. And there are some novel institutions, not the least of which is the rapid response mechanism that was set up to be able to have enforcement of labor standards vis-a-vis individual companies in a faster and more direct way. And we're going to hear today about two of those first cases that are in the rapid response mechanism. And we're going to hear about two cases that are labor standards cases that are state to state. The case that is the first case, which is about Tridonex, we are going to have the pleasure amongst our lawyers of hearing from Ben Davis. Ben Davis is the international director of the United Steelworkers Union. He previously has worked at the Solidarity Center and was the Mexico officer for the Solidarity Center. He is one of labor's leading experts about labor rights in Mexico, and he is a leader in preparing the case about Tridonex, which is a facility that Susana Prieto and SNITIS, the independent union she has helped create, has been trying to organize an independent union for. This case, Ben will speak about first, and then we're going to hear about the state-state cases and about the report. So it's my honor to introduce Ben Davis. Ben, please.
Hey, thank you very much, Lori. Thanks, everybody, especially Susana for being with us, because I know she's in the middle of some very interesting activities right now. And Danielle, for all your work on the report and everybody here. I think the Tridonex case, which was filed under the rapid response mechanism, was filed with the U.S. Trade Representative, and they're now in a 30-day period of internal consultation, which ends on June 9th, and then they will make a decision about whether to go forward with the case and engage in formal consultation with the Mexican labor authorities. The case really comes out of, I won't tell you all the history because this is Susana's history. I don't want to be telling her story to you, but it comes out of a massive uprising of workers in the city of Matamoros, which is along a center of maquiladora production, low-wage export production to the U.S. that happened in 2019. It was sparked by an increase in the national minimum wage. Workers rose up and demanded that they get the increases that are actually in their collective bargaining agreements, which have never been enforced. With Susanna's leadership, they created an independent union, and they won. Amazingly, they won these wage increases. What they weren't able to win in about 45 factories that were involved in this was independent democratic union representation. Not because Sanitas didn't try, but because the system is stacked against them. And this is the core of what we're talking about with the problems with the old NAFTA that Lori referred to, and that a lot of people in this audience know a lot about. And it's pretty straightforward. The workers don't get to see their collective bargaining agreement. They don't get to elect their union leaders. They don't get to engage in what we would consider to be, democratic collective bargaining. Anyone who steps out of line is fired or worse, beaten up, shot, disappeared. Many documented cases that are unresolved, throughout Mexico. And this system has been in place for a long time, over 50 years. And the goal of the USMCA, or our goal in the context of the USMCA, was to bring about real changes to that system. And that included both the mechanisms that are in the treaty itself, the rapid response and other provisions, and significant changes in that Mexico committed to make in its labor law over a 4-year period. We're now 2 years into that 4-year period, and there's certainly a basis to assess, how well they're doing, and there are a lot of concerns about how they're doing on that implementation. I think. Do you want me to say more, Lori, or I think that really kind of frames it? I don't want to, I think Susanna should tell the story of what's actually going on right now with the case. Just that, we worked, this case was filed jointly by the AFL-CIO, Service Employees International Union, Public Citizen, and Sanitas. So you have several of the actual litigants on the call here. And we see this really as a critical test, along with the case that USTR is now self-initiated on General Motors, which we could come back to. Also a very interesting situation. But everyone in Mexico is looking at these cases to see, essentially, is this for real? Is Mexico actually going to do any of the things that it committed to do? Because there is a long history in Mexico of governments promising change and not delivering change. And then if they don't, is the U.S. actually going to take any substantive action that would dissuade employers, corrupt protection unions, government officials from acting the way they have been acting for the last 5 decades? So I'll stop there, and then we come back in questions.
Thank you very much, Ben. We will come back to you with a little after Susanna for a little bit about that about the GM case. But it is now my high honor to introduce Susana Prieto Terrazas. She is an amazing champion of workers in the maquiladora sector in Tamaulipas and in Juarez. She is a relentless lawyer and brave leader. Many people on this listening here today helped elevate her cause in the United States when she was politically imprisoned under trumped up charges related to her advocacy for working people. She is somebody who is in the middle of what it will mean on the ground if these new labor rules do and do not work, and what it can translate to for workers in Mexico having better wages, a better life, better conditions. Or she's going to be at the front line of being able to let us know the change is not real. So it is my honor to be able to introduce Susana Prieto. Susana, please.
Lo siento, estaba buscando mi micrófono. Muy buenos días, gracias a todos por la invitación a este panel. Realmente para mí es un gusto compartir con todos ustedes y sobre todo a nombre de los trabajadores mexicanos y especialmente de los trabajadores de Tridonex, de Tamaulipas y Ciudad Juárez, con los que hemos tenido tanto contacto precisamente para saber, como ha dicho ahora Lori, si realmente está funcionando o no este tratado o nuevo tratado de libre comercio, ahora llamado por nosotros el TEMEC, y fundamentalmente si está trabajando el apartado 23, porque en lo que interesa en este panel es, por supuesto, una cuestión de carácter laboral. ¿Existe o no libertad y democratización sindical en México, atendiendo a que el TEMEC constituye, junto con la Constitución Política de los Estados Unidos Mexicanos, la ley suprema de mi nación, de México? Y nos encontramos con que no. Nos encontramos con que el panorama que se vende hacia el exterior, tanto por parte de las empresas como por los sindicatos blancos enquistados en un sistema político que pues ya venimos arrastrando desde el siglo pasado, podemos decir ahora, pues no está funcionando, precisamente porque los sindicatos surgen en México como parte del partido político, el Partido Revolucionario Institucional. Posteriormente, en la alternancia en el poder, también el Partido Acción Nacional se ve beneficiado por estos y desaparecen, por ejemplo, al sindicato de Luz y Fuerza y a Luz y Fuerza completo, porque les estorbaba en un momento dado para los intereses de gobierno. No funciona el TEMEC, no funciona. ¿Por qué? No solo por la corrupción de los líderes charros sindicales, sino porque hay corrupción de algo que yo he venido denunciando desde el año 2015 y que parece ser que hizo eco o detonó con la privación ilegal de mi libertad, porque al hacer pública la situación que acontece en México, pues entonces me convertí en el enemigo público número 1 de los dueños del dinero. Y los dueños del dinero, pues son los empresarios, y en este caso en el norte del país, pues yo ataco fundamentalmente a la inversión extranjera, a la inversión transnacional o a las maquiladoras. Las maquiladoras que desafortunadamente para nosotros se han mimetizado en la corrupción que existe en el país, y que yo he declarado públicamente que no existe sindicato corrupto sin empresa corrupta, porque los trabajadores del país no tienen educación suficiente respecto de una lucha sindical, solamente obedecen las indicaciones de sus departamentos de recursos humanos, y si no las obedecen para pertenecer a tal o cual sindicato, inmediatamente son despedidos y además boletinados, porque en lugares como Matamoros, Tamaulipas, la CTM tiene el control hasta del aire que respiramos. Cualquier trabajador de industria, de servicio, de comercio o de cualquier área está controlado por la CTM. Entonces, si tú no haces lo que una empresa te indica, avalada, sostenida y soportada por su sindicato, que es sostenido económicamente con las cuotas por sus trabajadores, y que lejos de buscar, como tú lo decías, mejores salarios y condiciones de vida para sus trabajadores, se han constituido en el brazo derecho de los departamentos de recursos humanos de las empresas, pues entonces nosotros vemos que esto no funciona. ¿Por qué Matamoros? Porque esto estalla en Matamoros, porque Matamoros tiene los contratos colectivos de trabajo más impresionantes que yo he leído jamás a lo largo y ancho de la República Mexicana. Porque hubo un líder hace más de 30 años, Agapito González, que logró con lucha de los obreros y con concientización de los mismos que se incorporara a los contratos colectivos de trabajo de una cláusula donde los trabajadores debían laborar una semana inglesa de 40 horas, aunque bueno, también es americana, una semana de 40 horas y no más, con un pago de 56. Y además de eso, los trabajadores, como el pretexto de la industria maquiladora, ha sido desde finales de 1960 que se estableció en mi país, que era culpa del gobierno, responsabilidad del gobierno mexicano que no se aumentaran los salarios, porque el gobierno no lo permitía, porque el gobierno establecía el salario mínimo, y con esta charrería mantuvieron medio pues conformes a los trabajadores o resignados, porque yo a los trabajadores mexicanos les llamaría resignados a su suerte, resignados a vivir con salarios precarios, a que sus hijos no tengan oportunidades de salir de la pobreza, ni de ir a estudiar a la universidad, ni absolutamente nada. Bueno, pues resulta que este líder sindical llamado Agapito González, adelantado a su tiempo, dijo, entonces en México solo es obligatorio aumentar cada año el salario mínimo. Pero en México hace 30 años que nadie gana el salario mínimo, ni en la maquila, ni fuera de la maquila. Es algo irreal, es una utopía. No la pueden comparar con Estados Unidos ni con Canadá. Esa es una de las desventajas que nosotros tenemos. Porque cuando ustedes hablan de salario mínimo en sus países, es un salario obligado para todo el mundo. Aquí no, porque aquí simple y sencillamente no existe el salario mínimo. Por eso cuando el señor Andrés Manuel López Obrador llega a la presidencia de la República y a partir del 1 de enero duplica el salario mínimo, no se ve reflejado en ninguna parte porque eran muy pocos los trabajadores que en el país ganaban realmente el mínimo. ¿Por qué están enojados los empresarios? Pues porque ahora sí va aumentando. Desde que llegó Andrés Manuel López Obrador a la presidencia, también debemos decirlo, se dirá lo bueno y también tendrá que decirse lo malo. Si seguimos tratando de que nuestros gobiernos traten a los trabajadores con mentiras, nunca vamos a progresar. Se ha aumentado el salario en 2 años 146%. El salario mínimo, lo que no había pasado en la historia de los últimos 35 años en México, pero ha resultado insuficiente por la irrealidad del salario mínimo. Nadie vivía cuando llegó el presidente de la República con 88 pesos diarios por una jornada de 10 o 12 horas diarias. Vivían con 120 o 125, pero la obligación de aumentar cada año es solo para los que ganaban 88.36 y casi no había trabajadores de estos en la República Mexicana. La única salvación que tiene la clase trabajadora es el sindicalismo, pero el sindicalismo en México apesta, huele mal, provoca vómito. Al igual que hablar de políticos, los trabajadores se alejan y salen corriendo porque son el símbolo de todo lo peor que puede haber en el país. Lo mismo pasa cuando hablan de sindicatos. Ya cuando tratamos de hablar del Sindicato Nacional Independiente de Trabajadores de Industrias y Servicios, Movimiento 2032, tenemos reacciones de trabajadores que dicen todos los sindicatos son iguales de corruptos, son una bola de rateros, sirven al patrón, solamente nos quitan nuestro dinero en cuotas sindicales, pero no tenemos ningún beneficio de ellos. Ellos obtienen beneficios políticos y además se hacen multimillonarios, mientras mi salario solo decrece, mientras mis condiciones de vida cada vez son peores. Bajo estas condiciones, en términos generales, y para no aburrirlos, porque ustedes son expertos y lo saben perfectamente lo que pasa en el país, a cuentagotas, precisamente en enero del 2019, quisieron las empresas robar nuevamente el bono único anual a los trabajadores en Matamoros y ahí surge el Movimiento 2032. Una vez que se logra el aumento salarial y que se logra el pago del bono, yo no puedo encontrar una palabra para decirles cómo estaban los empresarios, pero es algo más que endiablados, como poseídos en contra de mi persona. Dijeron que me había mandado Donald Trump a desestabilizar el gobierno del señor Andrés Manuel López Obrador. Después hubo, y lo tenemos en todos los periódicos, Hubo quienes dijeron que no, que era Andrés Manuel López Obrador quien me había enviado a Tamaulipas a desestabilizar el gobierno de Francisco Javier García Cabeza de Vaca. Bueno, no dijeron que me mandó jamás el grupo terrorista porque dijo ya era demasiado, o porque los que escribían sobre el movimiento 2032 en Tamaulipas no sabían quién era jamás. Pero nada más les faltó decir eso de mí. Cuando tú pretendes defender derechos laborales en México, simplemente terminas en la cárcel o muerto. Y es muy importante que el mundo sepa esto. Si soy enemigo número uno es por la visibilidad que he hecho a nivel nacional e internacional de la precariedad de las relaciones obrero-patronales. No solo las nacionales en México, sino las que provienen fundamentalmente de los extranjeros. Ustedes por años escucharon a la industria maquiladora estadounidense decir que ellos vinieron a quitarnos el hambre, que gracias a ellos los mexicanos comían, que el desarrollo de nuestro país era gracias a la inversión de los estadounidenses, que ellos pagaban mucho más dinero de lo que era el salario mínimo, que las prestaciones de ellos eran incomparables. No me atrevería a decir que a finales de los 60 no lo eran, pero ¿a cuánto tiempo estamos de distancia? Estamos hablando de más de 50 años de diferencia, y ellos siguieron esta regla de al lugar que fueres, haréis lo que vieres. Y tenemos a la industria no solo norteamericana, sino china, taiwanesa, alemana, francesa, involucrada en la corrupción con los sindicatos blancos de mi país para precarizar las relaciones obrero-patronales, empezando por los salarios y continuando por todas las condiciones de vida. No se nos ha permitido ninguna votación libre. Los gobiernos, que esto es algo con lo que cierro, el gobierno mexicano con la reforma que hizo la Ley Federal del Trabajo para poder adecuarla al apartado 23 del TEMEC, en letra muerta. Nunca contemplaron que, o sí lo contemplaron, yo no sabría, porque a veces el gobierno es tan bien intencionado y a lo mejor la malintencionada soy yo, pero fíjese usted que los estados del norte del país serán los últimos a los que se aplique la reforma laboral, por allá por el 2023 o 2024, que el sexenio del actual presidente de la República vaya terminando y sepa Dios en qué problemas nos van a meter para entonces, y si venga otro nuevo presidente y entonces diga que va de retro Satán, el Señor está conmigo, y otra vez los fielders para volver a empezar y tener una ley arcaica surgida desde el movimiento revolucionario de 1917. No es posible que continuemos así. Es necesario activar el mecanismo que contempla como una arma legal, que no es política ni es personal en contra ni del presidente de los Estados Unidos ni del presidente de México, porque a lo mejor ni saben el lío que traemos por aquí, el señor Ben, Public Citizen, los sindicatos americanos, el SNITIS, queriendo que se aplique. Este mecanismo es un recurso legal que está contemplado en un tratado internacional de aplicabilidad obligatoria para Canadá, Estados Unidos y México. Y México no está cumpliendo con la libertad y democratización sindical. No estoy diciendo que haya mala fe en esto, pero estamos casi a 4,000 kilómetros de distancia del centro del país y tenemos un gobierno eminentemente centralista que tal vez no se da cuenta lo que pasa en el norte del país. Es urgente que el gobierno federal no siga diciendo que todo es cosa de Tamaulipas o de Chihuahua, o del gobernador Cabeza de Vaca en Tamaulipas o del gobernador Javier Corral en Chihuahua. Es necesario mover a nuestros gobiernos para que todo esto resulte en un beneficio para la clase trabajadora de la ciudad y del campo. Que si me demanda Estados Unidos porque no cumplo el TMEC en las maquilas, dijo el presidente de México, pues demando a Estados Unidos porque no se respetan los derechos de los trabajadores campesinos. ¡Bravo, señor presidente! Todos los que estamos unidos aquí, lo único que pretendemos es que se respeten los derechos de los trabajadores, que haya mejores condiciones de vida, partiendo por los salarios y las prestaciones adicionales a las mínimas que tienen establecidas en los 3 países actualmente. Si eso logramos, sería muy bueno. Debemos, como experta se los digo, quitar el control a los gobernadores de las 32 entidades federativas o estados en México, de las juntas de conciliación y arbitraje ya, si queremos que la libertad y democratización sindical funcione, porque no puede el presidente de la República estarnos diciendo, oh, esa es cosa de Tamaulipas o de Chihuahua, porque él, como presidente de México, firmó un tratado internacional que obliga a cumplir el TMEC a las 32 entidades federativas, y que si las empresas transnacionales haciendo actos de corrupción no lo quieren cumplir, pues entonces también el presidente Biden tendrá que hacer las regulaciones o las reformas que sean necesarias al TMEC para que realmente funcione, o para qué vamos a seguir teniendo tratados internacionales que no se van a aplicar. Más leyes siendo letra muerta, nadie quiere, no en México, en ningún país del mundo.
Susanna, thank you very, very much. And in the Q&A, we can hear more from Ben and from Susanna, and also my colleague Danielle, who helped with the brief on the Tridonex case, about the Tridonex case, the rapid response case, and the GM rapid response case. But, and we will hear more about the issue Susanna is describing, about how in the border states, in places like Tamaulipas and Chihuahua, the workers in Juarez and Matamoros, who Susanna has represented, right now don't have access to any court system, any labor system different from what it was like before the revised NAFTA, and what problem that is. However, before we get to that, it is my honor to introduce Rachel Micah Jones. She is an attorney and the founder and executive director of the Center for Migrants' Rights. It is a binational, transnational migrant rights organization that is based in Mexico and the United States. And her organization has petitioned the Mexican government to ask the Mexican government to file on behalf of several Mexican nationals who are working in the U.S. to file a case. They're petitioning Mexico to file a case under NAFTA's state-to-state enforcement. There's several different kinds of enforcement of the revised NAFTA of the USMCA. So Rachel's going to tell us about that case. And then there's another case that the Mexican government has filed, which she may or may not mention, that is a similar state-to-state case that also has to do about the treatment by the US of Mexican workers working here. Rachel, please.
Great, thank you so much. And thank you so much for having me. We all know that under NAFTA, labor was barely an afterthought. And at CDM, we had brought 2 complaints under NAFTA's labor side accord. And what we found essentially was that the agreement was basically toothless. It failed to provide sufficient remedy for workers and the migrant workers we represented in those cases. So when the renegotiation of NAFTA was announced in 2017, CDM mobilized with migrant workers and our allies to win enforceable protections under the agreement. Our efforts and the efforts of allies paid off. The USMCA includes an enforceable labor chapter, Chapter 23 of the agreement explicitly mentions protections for migrant workers and women. And under this agreement, labor violations can be adjudicated at the same level as other trade disputes. So on paper, I think the USMCA shows promise. Its dispute resolution mechanism could be a powerful tool to advance justice with migrant workers. And so now CDM is supporting migrant worker women in testing the potential of the agreement. When we look around like at job ads in Mexico, we see things like men only 18 to 35. These are job ads for workers being recruited to work in the United States. And seeing a job posting with those words, it's really startling at this point. It's actually shocking. And even more than a year into this world-changing pandemic that has pushed millions out of paid work, US employers continue to discriminate against women, posting ads like that one. To evade legal consequences, US businesses discriminate in Mexico, hiring men to work in the US with temporary H-2 guest worker visas. And we just saw this week that the US government announced the expansion of the guest worker programs. And so this is an area where there's lots of movement on the policy front. The petitioners in our case, Maritza and Adarelli, both faced gender-based discrimination. Adarelli was recruited to work in the US in protein processing. Specifically, she worked in crawfish and crab, and she has years been denied access to H-2A jobs or higher paying H-2B jobs. Now, the H-2A and H-2B are visas for temporary work in the United States. Maritza was recruited to work in the US as a farm worker with an H-2A visa, where she was sexually harassed by her employer and never received justice. Their cases are not isolated incidents, but rather representative of the deficiencies in the guest worker program and the US's failure to enforce its labor laws and promote standards. At CDM, we hear stories like Maritza's and Adarelli's every single day. The rampant discrimination is backed by data. In 2018, for example, only 3% of the H-2A visa recipients were women. And as part of our complaint, we submitted disparate impact analysis that confirms the widespread discrimination in the programs. US employers and recruiters discriminate, and in the limited circumstances where they do hire women, they channel them into lower paying jobs. Sexual harassment is not uncommon, putting women in impossible situations to support or to suffer these conditions, poor conditions, or to leave and potentially face blacklisting and retaliation. And there are a ton of barriers for these women. The US government's policies deny them access to federally funded legal services. The terms of their visas require them to return home so they cannot pursue their cases. The appropriations riders prevent Department of Labor from enforcing some of their protections. And there are a whole host of other barriers that deny access to justice to these workers. And the imbalance of power is directly embedded into the programs and results in systemic abuse from the moment of recruitment. For decades, the lack of government oversight has allowed employers and recruiters to discriminate against women with impunity. The US government has essentially delegated its responsibility to set labor standards to employers, granting them the ability to choose who has access to job opportunities in the United States, who can come to the United States and who can't. And we all know that who is receiving these visas are people with certain characteristics, men between the ages of 18 and 35 years old. So we worked with Maritza and Adarelli and members of our Migrant Defense Committee in a binational coalition of dozens of organizations, including progressive labor unions like the United Food and Commercial Workers in the US, the airline pilots, the teachers, laborers in Mexico, like the farm workers and domestic workers, and gender equity and human rights organizations from both countries. And on March 23rd, we submitted the complaint. And we heard, immediately after that the complaint had been received. And by March 31st, the Mexican government did notify us that the petition had met all of the requirements under Article 23 of the USMCA, and it had been admitted for review. In that time, we had conversations with representatives from both governments, and we raised the issues that women in these industries were facing. So we're talking here about agriculture and protein processing. And in those conversations, we understood that the Mexican government was using its consular network to then investigate more and to see what the abuses were in those industries for workers in farm work and protein processing. And so we were pretty pleased to see the letter from the Mexican government in May, asking for consultations under Article 23 of the agreement, asking for cooperative dialogue under Article 23. Because it really aligns with our petition and the issues faced by workers in those industries. And so we're pretty optimistic about at least the attention that this petition is getting and the quicker timeline, that of action in this circumstance, and hopeful that there'll be at least a little more attention to these complaints than there were under the NAFTA. Thank you.
Thank you very much for that overview. And again, folks who want to ask questions, get ready, use the Q&A function, and we will shift to the Q&A function and the Q&As right after we hear from our last presenter, and that is Danielle Rondell. He is the Research Director of Public Citizens Global Trade Watch. He was already hatched a lawyer and working in trade law after some work with the government in Colombia on trade issues when he came to the US to get an LLM at Georgetown, and also got an economics degree at Sciences Po in Paris. And we are very honored to have him as our research director at Global Trade Watch. Among the excellent work that Danielle has conducted is an analysis that is now being issued, published today as a new report that describes the process of implementation of the new labor institutions in Mexico that are required by NAFTA and by Mexico's reformed labor law. And the findings are quite stark. It points out a large shortcoming that you have heard from both Ben and Susanna, which is the institutional absence of change to date in the places where it's most needed. And we have some recommendations in this report that Danielle has authored about how to fix that. Danielle Rondell, please.
Thank you, Lori. Let me please thank you for all your thoughtful comments throughout the process of drafting this report, and I think that only made them better. I'm gonna share my screen so that people can see a little bit of the findings that we have. Let me know if you can see my slides. Okay, I think we should be good. So, Susanna and Ben already mentioned it, but we want to underscore the reason why we decided to do this report is that last year, during a webinar very similar to this one, Susanna gave an early warning about the uncertainty over the precise moment when the new labor courts will be operational in north of Mexico. She said it again today, and the fact is that despite the fact that there has been a lot of progress in certain places with the implementation of the labor reform, what's going to happen with the states in the north border of Mexico is very uncertain. And in order to understand the importance of the idea of the labor reform and how the new labor institutions play a role within the overhaul of labor laws and institutions in Mexico, it's important to take into account that this was a commitment made by Mexico during the TPP negotiations. And this led eventually to Mexico reforming its own constitution in 2017. However, the reform was never materialized in federal law until there was a renegotiation of NAFTA in 2019 and President López Obrador was elected. So in 2019, there was the reform of the labor laws, in which there are two parts that are very important for our purposes. First, new guarantees and rights for workers, but on the other side, the labor institutions, courts, and conciliation centers, where workers could actually claim their rights and could actually fight for the enhancement of their wages and working conditions. The problem here is that, well, it's not the problem, it's something that was understandable. So Mexico decided, okay, we're gonna implement this reform in a stage way. And they decided to divide the states in 3 groups and then assign a deadline by which each of these groups will have to have the new institution, the labor courts, operational. And it's important to take into account also, and this is a little bit into the weeds, but bear with me, that there are courts that decide over federal jurisdiction and state jurisdiction. So the court that decides over federal jurisdiction, and these are basically key sectors of the economy. So automotives, mining, metals, these kind of sectors, they have a court that is located in Mexico City that is already functioning, and that what the government decided when it did determine this schedule was that this court would only know cases that arise from states where the local courts are already in place. This is something that is important. We will discuss it a little bit more later on. And the other element that is important to take into account is that once a case is started under the old system, it will remain in the old system until it's finished. So the old local boards these boards are problematic because they have been colluding with employers and with protection unions for decades now. They will keep functioning many years after the implementation of the new courts in each of the states of Mexico. So as is pretty obvious with this map, we can see that the third stage where the new courts are going to be implemented only into 2022, the North is basically backloaded in that later stage. And this is something that is rather striking if we consider that the north of Mexico and other states are also in third stage. They accumulate basically half of the manufacturing output of Mexico. This graph shows how, while the third state, the phase 3 states have around 45% of the manufacturing output, those states in phase 1 that are the only ones that have currently the new labor courts have around 20% of the manufacturing output. And this wouldn't be a problem if we don't see this clear correlation between manufacturing GDP and the frequency of labor conflicts in Mexico. This is the reason why we found very striking that the government decided to leave last those states that had the highest industrial activity. Because when we look at the states, not individually, but we look at them as a group, according to the phase in which they are, we can see that phase 3 states have almost twice as much labor conflicts than phase 2 states. And they have 3.7 times more conflicts than phase 1 states. This is using data from 2016 and 2018. This is government data that is most updated that we found right now from INEGI, that is the Statistical Bureau of Mexico. And this is even more problematic if we see what happens with strikes. The great majority of strikes in the country happen in the states that have been left last. And those are the states in the north and also a couple of other states. So while there is 25.7 states new strikes per year in these states, in phase 2 states is 4.3, and in phase 1 is only 1.5 new strikes per year. So this makes it very clear that the states that needed most direly the new institutions are those that are not going to see them for an additional year. And that's even more problematic if we see that, as Susana mentioned, those states in the north of Mexico are those that are most closely linked to the international economy. They receive almost half of the FDI that gets into the country, and they export half of the products that go abroad. And this is something that is also important to take into consideration in the context of the USMCA, because if workers in the north of Mexico do not have local fora where they could review their cases and where they could actually claim for the enhancement of their working conditions, then they're going to reach out to international partners and they're going to make use of the USMCA tools like the rapid response mechanism. And this is something that increases liability for Mexico. So it's in Mexico's best interest to give workers the right forum to redress their claims in Mexico. So what are the policy recommendations that we include in the report? They were also mentioned by Susana. We are just pointing very specifically to what could the government do to enhance the situation. And it's first, and this is something that I forgot to mention initially, and it was that this schedule that I was mentioning before was reformed several times over the past 2 years. So the states that were part of phase 1, phase 2, and phase 3 were changed constantly, with the only constant that was the phase 3 states were those that represent half of the manufacturing output. But other than that, they were changed, and they were changed because of the pandemic, and that's understandable. But also that introduced a lot of uncertainty on when would the new institutions be in place in different places. So what we're saying now is you can change it again, and you can include in phase 2, where the new courts should be operational in October of this year, and you can include Tamaulipas, Chihuahua, and other states with high industrial activity and with a lot of labor conflictivity. And that will be something that would allow workers in those states to have new institutions to redress their claims pretty much in a couple of months. And the other solution, which is important, that I was mentioning with the difference between local jurisdiction and federal jurisdiction, is that the Federal Labor Court for Collective Matters is already functioning and is receiving cases. It has handled like 73 cases by now. And this court has competence over all of the cases that are arising in these key industries, metals, automotive, auto parts, in the entire country. So it will be easy for the judiciary of Mexico to amend its regulation to say every case in every state of the country that is related to these sectors has to go to the new institution. And this is something that could be done and is in the best interest of Mexico and workers across North America, because basically the whole idea of the USMCA is to provide a forum, is to provide the opportunities to workers to have forums and to have rights so that they can increase their wages and they have dignified working conditions. And this is something that could be done fairly easily, so that we can achieve that objective.
Daniel, thank you very much. So the report can be found at tradewatch.org. And again, the findings: the states in Mexico that most desperately need the new labor system are the last where workers will have access to real justice. But in that scheduling, there is flexibility. And so the recommendation of this report is, number one, the Mexican government use the discretion it has to allow workers to go to the already functioning federal new reform jurisdiction for auto and other sectors, which right now is being restricted to only workers in states that have the new system, where the new system is not in place where workers need it most. And that, number two, the phase-in be altered to front load more of the states where there are the most problems, given, as the report documents, the old institutions, the leaders of them think they'll be around for years with backlogs of thousands of cases that they'll be deciding. So with that, we're going to turn to Q&A, and I hope we'll be able to discuss a little bit more specifically, as some of the comment links let you dig into the case at Tridonex, where Sanitis and organizers in those facilities have tried to organize an independent union, have tried to get it accepted and recognized by the company, where hundreds of workers have been fired for trying to exercise their labor rights. This is the first rapid response petition. And then again, at a GM plant, the US government has filed an additional rapid response. This was ballot tampering, very clear ballot tampering by the Protection Union with respect to an election for a new union. Plus, there is the case Rachel talked about, and then there is an additional case the Mexican government has filed also with respect to migrant workers' rights. So the first question that we have is from reporter David Brooks from La Jornada. And he is asking, are there efforts to defend and promote labor rights for U.S. workers, not immigrants, under the Usmca? And I will also add his second question, which is, what does the apparent nomination of Ken Salazar, former Secretary Salazar, as next U.S. ambassador to Mexico imply for labor rights issues in the binational relationship? And any of our panelists, would you like to take those questions? Okay, I am going to, what?
A shot on the question, David, about U.S. workers. So our complaint is on behalf of migrant workers from Mexico who are working in the industries in farm work and in protein processing in the U.S. But what part of our advocacy at CDM is really joining forces with organizations, with workers in these sectors and in other sectors, because what we understand is that if any workers are vulnerable, the whole workplace suffers, all workers at those workplaces suffer. And so part of our approach is really to ensure that all workers have access and can enforce their rights and can organize on the job. And so, I'm happy to talk offline about, other efforts that really bring together immigrant workers, U.S. workers more broadly to advance justice with workers. So feel free to reach out after and can share more about those efforts.
Susana.
Pues yo no sé si Ken Salazar tenga dentro de su agenda los derechos laborales binacionales, pero nosotros estamos trabajando para que esté dentro de su agenda y de la agenda de los presidentes de ambos países, porque si las agendas no son laborales, en primera intención con la crisis económica por la que atraviesa Estados Unidos, que es inminente y que por supuesto pues ha venido a decir, no descubrió el ministro de Canadá ningún secreto que hubiera oculto por allá en el fondo del mar y que solo pudiera descubrir un gran pirata, ¿no? No tenemos ya ni en México y muchos trabajadores en Estados Unidos la capacidad de adquirir. Entonces, los dueños de empresas, los que de verdad producen algunas cosas, Estados Unidos no produce muchas cosas, pero produce coches, ¿no? Y entonces se está terminando la capacidad de adquisición de consumo. Entonces yo creo que esto de los salarios y la agenda laboral tiene que estar como prioridad en la agenda del nuevo embajador, y si no, estaremos aquí a través de organizaciones como Public Citizen, a través de SNITIS, a través del Sindicato de Acereros y de todos los sindicatos independientes que en México ya son más de 53, burócratas y no, que vamos a juntarnos y vamos a estar en la lucha para tratar de que esto sea una verdadera agenda en ambos países.
Thank you, Ben.
Yeah, just to add real briefly, I mean, the way USMCA is structured, it's not equal. So the US, through the rapid response mechanism, basically has the ability to bring a complaint regarding any what's called a covered facility, which is all of the major manufacturing sectors in Mexico and a lot of services as well. So, tens of thousands of workplaces. Mexico is extremely limited in what it can bring under rapid response. It can only bring a complaint that involves where a federal court has enforced an order of the National Labor Relations Board. Well, I think there were 12 of those last year. So it's very discriminatory the way it's negotiated. And, I think from the perspective of, U.S. workers in those sectors, it would be great if Mexico, which, in many ways has a strong history of worker rights advocacy, and certainly of advocacy for the rights of Mexican workers in the U.S., could get in there and, have the ability to bring complaints as well. For right now, we have the state-to-state mechanism, and so it's really important that CDM and others use that mechanism, but we should look for a broader expansion. Our goal here is to raise the wages of workers on both sides of the border, but particularly to raise the wages of Mexican workers because, it's a 10-to-1 ratio. It's been a 10-to-1 ratio for half of a century, and there's no way to have fair, just economic development. There's no way to have democratic trade unions. There's no way to have democracy when you have that level of inequality based on a border. So we have to find a way working with the workers in Mexico to overcome that, and I think that's what everybody here on this panel is trying to do.
Thank you very much. A question from Judy Ansell, Director of the Cross-Border Network for Justice and Solidarity. What is Susana's current legal situation? And how can American unions and non-governmental organizations help?
Mi situación es fatal, sigue siendo casi la misma, la única diferencia es que no estoy ahora tras las rejas, pero pues bueno, todo mundo conoció ya la resolución de la jueza de Matamoros con un claro mensaje del gobernador, a parecer prófugo de la justicia ahora, un gobernador que gobierna a través de Twitter, que es cabeza de vaca en Tamaulipas. Y creo que por lo que se ha expuesto de los presuntos delitos por los que puede ejercitarse acción penal en contra de él, ya podrán establecer ahora con mayor claridad el peligro que corría mi vida y la denuncia que puso mi hija ante la embajada norteamericana cuando estaba en el penal de Tamatán. Me expulsaron del estado, me prohibieron trabajar en Tamaulipas 2 años y medio, me han violado mi libertad de tránsito, me han prohibido viajar no solo a Estados Unidos, sino a 193 países en el mundo. No puedo salir de México, no puedo vivir en ningún estado de la República que no sea Chihuahua, donde tenía 2 órdenes de aprehensión que a estas alturas en que estamos hablando ya son autos de vinculación a proceso, uno de falsedad en declaraciones judiciales, donde detrás están las representantes legales de Johnson Controls, el líder de vestiduras automotrices más importante de los Estados Unidos de Norteamérica, ahora es la maquiladora denominada Adientaqui, que han ido por una persona a Estados Unidos que vino a fincarme cargos y hacía 30 años que no estaba en este país. No sé cómo sabe ella de que yo he cometido hechos delictuosos, pero así estamos con uno de los procesos. El otro proceso el de privación ilegal de la libertad de 2 gerentes de la empresa Electrocomponentes de México el 20 de abril del 2020. Los cargos, pues obvio, el 10 de marzo del 2020 me acusan de haber instigado, esa es la palabra, motivado, impulsado, instigado, como el autor material de un crimen que acusan haber cometido a los trabajadores de Tridonex el 10 de marzo del 2020, después de que tenían 2 días en un paro laboral porque no les aceptaba la empresa la solicitud de que dejaran de cobrarles cuotas del SITME, el sindicato de la CTM, y porque ellos pertenecían a SNITIS y porque además el artículo 110 de la nueva Ley Federal del Trabajo les permitía no pagar cuota sindical. 2 días pararon la producción, 8 y 9 de marzo del 2020. Como no hizo caso la empresa, el 10 de marzo fueron a la Junta de Conciliación. Me dijeron que si podíamos presentarlo por escrito, les dije que sí. Les llevé el escrito, estuve 10 minutos porque no encontrábamos a nadie que nos recibiera el escrito y entonces fui acusada de la comisión de los delitos de motín o amotinamiento, que desde 1875 nadie era juzgado en Tamaulipas por ese delito, coacción de particulares, delitos en contra de servidores públicos y amenazas. La jueza determinó que debía prevalecer la presunción de mi inocencia y como era inocente me condenó a pagar 66,000 pesos de la reparación de un daño, de un delito que nunca cometí porque no estuve ahí. Los trabajadores estaban manifestándose libremente y es un derecho constitucional, pero yo no estaba. Ahora empiezo a entender un poco más claramente el juicio que está en Chihuahua por privación ilegal de la libertad de 2 gerentes de Electrocomponentes de México. La empresa estaba clausurada por la Secretaría del Trabajo Federal desde el viernes anterior y aún así dicen que privamos de la libertad personal a 2 gerentes y 9 empleados administrativos que violaron estos sellos de clausura y sí estaban dentro de la empresa, pero porque fueron a convencer a los trabajadores de que se fueran a casa en la pandemia el 20 de abril del 2020 con el 50% de su salario, cuando el presidente de la República y la secretaria del Trabajo Federal en México dijeron que debían pagarles el salario íntegro. Y no era un salario como el que promueve la industria maquiladora a nivel internacional, que ellos pagan más que la industria mexicana, que sus salarios son inalcanzables. Era nada más que el mínimo, 185 pesos diarios, y querían obligar a los trabajadores: o firmas este convenio de que te vas a casa porque nos está obligando el presidente por no ser empresa esencial y evitar la propagación del virus, te vas con la mitad, 92 pesos, el equivalente más o menos será a $5 diarios, durante el tiempo que diga el presidente, y pues esto implicaba que los trabajadores fueran a morir de hambre a su casa. Me mandaron llamar, me preguntaron si era legal que los obligaran a firmar el convenio del 50%, les dije que no, públicamente, y entonces el juez ha dicho en Chihuahua que mi calidad moral como líder de la clase obrera en este país, en redes sociales, que mi calidad moral y la obediencia que me deben los obreros por este servicio social y estas actividades loables que hago para informarles sus derechos, me constituyen una líder, y que si bien es cierto no existen elementos para acreditar que yo privé de su libertad a los gerentes ni al personal administrativo, sí puede existir la posibilidad que sea la instigadora o la autora material de la exteriorización de la conducta de trabajadores frustrados, enojados, molestos por la violación de sus derechos humanos y laborales. Yo estoy agradeciendo que no mataron a nadie, porque como soy una líder moral, si algún obrero del país llega a cometer un crimen, falta que cualquier gobernador me culpe de ser la instigadora de la comisión de ese delito. Estoy sujeta a proceso en los 2 procesos en Chihuahua y tengo esa sentencia que está impugnada por un amparo que interpuse por violaciones a la Constitución, primero en Reynosa, donde se dictó la resolución que me expulsa del país, que me impide, del Estado, que me impide trabajar, que me impide viajar, que me impide vivir en un lugar que no sea Chihuahua, y el juez de Reynosa lo envió a Matamoros y dijo: no, yo no soy competente, Matamoros que resuelva, y el de Matamoros se lo volvió a regresar al de Reynosa, y le dijo: no, yo tampoco soy competente, porque aquí no resolvió el juez de la Alzada, y el de Reynosa se lo mandó a un tribunal colegiado federal que todavía no resuelve y que probablemente pase la sanción inquisitoria que me impuso la juez, basada en la presunción de mi inocencia, y en 2 años y medio no se resuelva mi amparo. Esa es la situación actual que presento jurídicamente. Nadie me puede ayudar. Me preguntan que cómo me han podido ayudar ustedes. Pues son los que me han ayudado y son a los que debo la libertad. Son quienes intervinieron ante el Congreso norteamericano para exponer mi persecución política, la privación ilegal de mi libertad, la fabricación de delitos por defender a los trabajadores en cuanto a la libertad y democratización sindical. Pero no hemos podido hacer nada más, aunque le pidieron al presidente de la República que lo hiciera. Es importante destacar que durante toda mi vida, que son muchos años ya los que tengo, no suficientes, pero muchos, he vivido en un país que se mueve con el presidencialismo hasta ahora, en el que Andrés Manuel López Obrador es ninguneado por todos los gobernadores de la oposición, entre ellos el de Tamaulipas y Chihuahua, porque aunque le pidió les pidió a solicitud de tanta organización no gubernamental, sindicatos, congresistas mexicanos, americanos, que retiraran los cargos, le dijeron al presidente de la República que no lo harían. El poder del dinero está por encima de todo.
Thank you for that update, Susana. One thing that I think we can pledge is that your case and your legal situation in any moment where your many allies in the United States who are in Congress, who are in the labor and civil society movements, will be on top of every development and will fight for your rights and your freedom to continue your leadership, and are basically waiting to hear any way that we can help in this very complicated, unfair legal persecution, political persecution through the legal system of you. It is, sadly, we have run our time. And what I would like to do is just give a moment or two to each of our four panelists to close and mention any other matters that they would like to wrap up. But I'd like to do that in the context of raising one more question, which maybe everyone can work in, which is from Kathleen Stout, who is a longtime border activist and scholar with Mujer Obrera. And she is asking, after the USMCA complaints about the GM plant in Guanajuato, Mexico's Minister of Foreign Affairs criticized in a letter to the US Secretary of Labor on May 13th, the US failure to apply labor laws to migrant workers in agriculture and meatpacking industries. So the whole smorgasbord of different cross-cutting challenges. And her question is, and this is to just have everyone sum up, what is your view about how all of these mutual complaints affect the cases covered in this panel? So if I may please, in sort of reverse order, may I please start with you, Daniel, and then I will go to Rachel, and I will go to Ben, Susana, and then to Ben. And of course, thanking all of our excellent panelists and all of you, but please, I'm filibustering a little so Daniel can collect his thoughts. Sorry to do this to you, Daniel. Daniel.
No, it's good. I think that it's a good question. I think that what USMCA did was give us a testing ground of how pro-worker, also pro-environment trade agreement could work. And this will have some backlash, and these kind of attacks, I think, that are expected. What's important, I think, is that labor, civil society, and different groups actually use the mechanisms that were so hard fought and that were achieved and were included in this agreement, so that we can keep moving this agenda. Because if we don't do it, it's not gonna happen, and it will be a huge missed opportunity to keep promoting a vision of trade that is a little bit different from the one that is very different from the one that has been imposed for decades now, and is that trade is just but a tool to achieve social objectives, nothing else.
Thank you very much, Daniel. Rachel, Micah Jones, please.
Sorry, struggling with the mute button. I think we have to wait and see how it all plays out, but we definitely want to see this agreement and the dispute resolution mechanism be meaningful for workers. What I would say in terms of like a last closing thought, just to stay tuned, we do have an announcement in our case that we'll be sharing on June 4th, next Friday. So please stay tuned ahead of the VP's visit to Mexico. So just stay tuned, and that's it. And, just generally, like, I think for us, at CDM, like, our opinion is that a range of complaints is good in order to kind of test the mechanism. And we're excited to see how they play out, and we're hopeful that there will be meaningful resolution of these complaints, and that this will be a meaningful tool for workers like Adareli and Maritza, who are recruited in Mexico to work in the United States. So, thank you.
Thank you very much. Susana.
Perdón. ¿Oí mi nombre?
See? Any concluding statement?
Perdón.
And would you like to make any final few minutes of conclusion?
Sí, por supuesto, es muy importante para mí una pregunta que estaba leyendo, perdón, me distraje, de cómo es posible democratizar a los sindicatos en México si no democratizamos sindicatos en Estados Unidos. La democracia es un término pero tan frágil, pero tan inentendible. La democracia implica la participación de todos los trabajadores. La democracia implica demostrar a los trabajadores que los sindicatos no son un mal social, que no son un aliado del patrón. Es necesario entender que nosotros ni queremos que las empresas se regresen a Estados Unidos, ni queremos dejar a los trabajadores sin trabajo, ni queremos que los gobiernos de nosotros se peleen. Es muy importante demostrar a los trabajadores que realmente dentro del proceso de democratización se quiere su bienestar. Queremos prepararlos a ellos. Por ejemplo, Sindicato Nacional Independiente de Trabajadores de Industrias y Servicios, Movimiento 2032. Todo mundo me pregunta en México, oiga, ¿y su sindicato? No es mi sindicato. Los sindicatos no tienen propietario, son los trabajadores, los miembros del sindicato quienes tienen la intervención directa en estas decisiones. Pero también debemos hacer un llamado a la clase obrera, tanto de Estados Unidos, México, Canadá y de todo el mundo. La participación, así como hace falta la participación para la designación de nuestros gobernantes y dejar de abstenernos de votar, así hace falta la participación de los trabajadores y las trabajadoras, ilustrándonos de cuáles son sus problemas y cuáles son las posiciones que tienen para resolverlos, que se acerquen, que vayan, que no vayan obligados, que vayan conformes, con metas, con proyectos, con objetivos claros, a decirnos efectivamente vamos a darle una oportunidad a la democratización. En México se llega a hablar por algunas personas de que es mejor desaparecer los sindicatos. Yo no veo mayor situación que podría empeorar peor la situación de los trabajadores de todo el mundo que la desaparición de los sindicatos. Si con sindicatos sirviendo a las empresas están como están, sin sindicatos con el control directo de las empresas, creo que no habrá ninguna posibilidad para la clase trabajadora. Es importante que los obreros y obreros entiendan que ni Lori, ni Daniel, ni Ben, ni Rachel, ni el presidente de los Estados Unidos, ni el presidente de México van a poder lograr la democratización de los sindicatos en nuestros países. Ese también tendrá que ser trabajo de los obreros y de las obreras, y nosotros vamos a trabajar incansablemente quizá por ver realizado un sueño, y quizá ese sueño no lo veamos realizado, ¿verdad? Pero vendrán unas nuevas generaciones. Hay que seguir sembrando esta semilla porque no puede ser posible que la brecha que existe de diferencia entre los dueños de las empresas, que cada vez son más millonarios, ya tienen dinero asquerosamente que ni siquiera se pueden gastar 20 generaciones de ellos, y entre más ricos son ellos, más pobres son sus trabajadores. Irnos a las tendencias humanistas, que no capitalistas, ni socialistas, ni comunistas, en las que está todo mundo todavía inmerso, creo que podría ser una gran solución y que podría llevarnos, por supuesto, a democratizar no solo los sindicatos en Estados Unidos y en México, sino también nuestros países y sus políticas.
Susana.
I can't really top that.
I was just going to say, Susana, you just like dropped the mic.
Yeah.
Good luck, Ben.
Yeah, no, I agree with that. And look, the U.S. Organized labor and independent unions in Mexico and a lot of great lawyers and civil society activists have worked together for decades, actually, to try and bring about these fundamental changes, giving workers in Mexico an opportunity to see their collective bargaining agreements, to negotiate democratically, to elect democratically their own leaders, and to fight for higher wages. I think we've made a lot of significant progress on that. There are opportunities. There are a lot of challenges and a lot more to do, but we have a coyuntura, we have a moment with 3 more years of the Lopez Obrador administration and 3 more years of the Biden administration and maybe more. And there's an enormous amount that needs to be done in those 3 years, but we've never had a better political alignment to do it with all the challenges that we face. And so it's really our challenge now. If we can't make some real progress in 3 years, then shame on us. Thank you.
Thank you very much. Thank you to all of our amazing panelists, to all of you for sticking in there. Martin Del Campo, yes, there will be materials available, including the report that Daniel was summarizing at tradewatch.org. A video of this and a transcript of this excellent webinar will also be available at tradewatch.org and perhaps at our partner groups' websites as well. A final thank you so much to everyone, our participants, for their words of wisdom, for all of the hard work to make a reality, better workers' conditions and wages in North America. And to the audience, thank you very much. Thank you all, and good